A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. Lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord, and your lordships also, my lord. That's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a series, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. Lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, Lord, any kind of posts are being made. I know, my lord, your lordships cannot control that. But the question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rodgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of para 221.
That's
as judges, we decide according to the Constitution.
correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my lord, for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
All right. What order?
We just one fact. Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion.
One fact. I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we will not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
One will allow us.
Mr. Rodgi, no, Mr. Rodgi. I told you the reason for it. We are now at a stage when the judge.
I am not on my application. Not that it become infectious. I am now only saying.
No, Mr. Rajeev, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
I didn't get a proper assistance. So just one. The grievance of those who will now be deemed that you have given to A party, you have given to B party. That will be
your side to ask. Lord, one more clarification.
What we did that we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition.
No problem.
Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization?
Answer is yes.
The answer is yes.
Lord, only one line, my lord. Only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your...
He has done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my lord. That by disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of the
Yes, but maybe treated as one.
We must just tell you that we respect this very responsible approach which the Solicitor General has adopted of, because, clients apart, who you are representing apart.
It is really painful, my lord, when the people before the court start, my lord, a media campaign to embarrass the judges.
Thank you for saying that you don't
very, my lord,
associate with the mentioning. Thank you for saying that you don't associate.
Because there is no level playing field. I can't hold a press conference.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are...
Last order, the election commission has put out the sealed covers, but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into all that, Mr. That's not our remit at all. What has happened after the judgment is not something we are concerned with.
Not after the judgment. What I am saying, what I am saying is this, that since the order of the...
Very recently I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. If there is the property of the nation. And,
I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the election commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not addressing your lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Unfortunately, public interest litigation have now become publicity interest litigation.
It is publicity interest litigation. It is, my lord, there are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And Lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships, in your lordship's majesty, would not know, my lord, what are the hidden agendas behind.
Just dictate a short order. I think, we are necessarily expanding upon the remit.
Because the major political parties have not disclosed the donor.
Just give us 2 minutes to
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
they have filed an application.
Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication,
yes,
right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order, 12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I am saying that...
modify that date.
No, the only reason, because your lordship asked the political parties to give donor details to the election commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties...
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But for that period of 2018 till...
Oh, that
So, we are not sitting in a review.
we have taken a conscious decision.
We are faced with a situation where the...
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
No.
And
In the light of the disclosure which has come to light of the political parties, that's why I'm saying.
And it is not a
If the political parties had disclosed the donor details, this would not be required.
draw the line somewhere, we had to hold the balance. We've held the balance ultimately.
As your
I
lordship
choose that.
pleases, but I just...
Can I just add one sentence? Lordship said all the details. Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying when a lordship said all details, my lord, in my respectful submission, it will be.
Mr. Salve,
No, my lord, lordship, just permit me a minute.
Salve has fairly stated that he will
Lord.
all the details. Why?
Yes, yes, well,
No, my lord, if I can just show.
and data are already
What your
disclosed.
lordship would say, my lord, I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. My lord, this will cover all the details, not in my respectful submission.
My lord, this is now asking us to sit down and collate one.
This
with
is a
the other.
submission made to the court. Just like Mr. Salve made a submission to the court. I'm making.
yeah, we need.
Very well. I'm making a submission to the court. Mr. Salve
No.
asking us to do whatever. Look,
Please permit my lord the Chief Justice to dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord. I filed that IA. For a preview, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, then, very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your lordship said, my lord, I have not pressed the
So
application.
Bhushan, there will be no end to it.
IA, what is the IA number, Mr. Ansariya? Just 1 second, Mr. Bhushan. IA number which you are not pressing is IA number?
Diary number 12580-2024, which is MA number, MA diary number.